Hi, my name is Robert Shelley of Chelle Law, and my law firm assists physicians with employment contract issues. Today I'm going to talk about what is an arbitration clause in a physician contract. I'd say 10 to 15 years ago, arbitration clauses were not, very frequent. However, nowadays, I'd say the vast majority of physician contracts include an arbitration clause. So let's kind of talk about the dispute resolution process for a physician, and then we'll go in detail about what an arbitration clause is. So in any physician contract, it should state if there is a dispute in some way, so maybe one party thinks the other is in breach of contract, and maybe the other party says, no, we're not, and they just can't reach some kind of resolution. The contract should state, one, which state's laws are being used. So it should be the laws of the state where the physician is providing care. A lot of these private equity, venture capitalist companies are kind of gobbling up physician practices. And so many of them could be run out of Florida, for instance, but the physician is practicing in Texas. Well, in those contracts, usually for those specific situations, it can state that even though the physician is practicing in Texas, the Florida law will be used. You want to make certain it's the law of the state that you're practicing in. And then there also could be some language about venue. So like where, if litigation was brought, so if someone had to sue the other party, where will it, be brought, in what court? And so, like for instance, here in Maricopa County, in Phoenix, many of the practices here will just state if there is a dispute that ends up in litigation, the case has to be brought in Maricopa County Superior Court. So, what the state law is used, what the venue is, and then many contracts, especially those for like hospital networks, could even list like a dispute resolution process. So first it could say, all right, the parties will attempt to reach some kind of agreement through mediation. And so mediation is just simply, usually an attorney or retired judge will attempt to, get the parties to reach some kind of compromise so that they can move forward with things. It's not binding. People can, if they're forced to participate, they can do so pretty passively. But if a settlement can't be reached, then generally it can go two ways. The contract could state, all right, if mediation is unsuccessful, then they can just go straight to litigation. Or it could say, all right, if mediation is unsuccessful, then they have to go to arbitration. And so arbitration is where, once again, either an attorney, a retired judge, someone like that will hear both sides of a case, and then they'll make a binding decision. So basically the parties are giving up their rights to sue the other, and waiving any kind of jury trial or anything like that. And it's, no matter what happens, we're going to arbitrate. The arbitrator is going to render a binding decision, and that is the decision. There will be no court process involved. Is it unfavorable to one side or the other? Well, strategically, most of the time, I think the kind of prevailing theory is that most juries are more sympathetic to the employee. So in this case, it'd be the physician versus the big hospital network conglomerate. So I would say in that matter, yeah, that's true, but litigation can also be lengthy and expensive, and arbitration can cut down, one, on the litigation costs, and then two, time more than anything. And arbitration can happen very quickly, whereas a litigation can last years. And I find that most physicians don't want that type of thing hanging over their heads. They want to, if there is some kind of major dispute, they just want to get it resolved and move forward, most likely with a different employer. But they still don't want to have to, think about the pending litigation at all times. I don't think it's unfair one way or the other. Generally, the arbitrator will be agreed upon by both parties, meaning they'll be, neutral in most respects. And then there's kind of limited discovery, which means a sharing of documents. It's kind of like pared down litigation. And then after the arbitration is over, usually the arbitrator will render some kind of brief written, kind of summary, and then render their decision of what it is. It could be just a monetary award, which is normally what it ends up being. So that's what an arbitration clause is in a physician contract. I don't think a physician could be, scared about signing this or thinking it's unfavorable. Most of the time, the smart people who put the arbitration clauses in will say exactly who they're going to use or what type of arbitration. So you could do AAA, JAMS, AHLA, which is the American Health Lawyers Association, also has a pretty good arbitration process. Maybe there's an arbitration process in the county that the physician is working in. Sometimes they'll have that in there as well. But, usually it will be spelled out. For an arbitration clause to be enforceable, usually it needs to be, at least in my opinion, should be fairly lengthy and should really kind of be outlined. Like, you are giving up your rights to sue. You are giving up your rights to a jury trial. So some that just kind of stick a very, like a sentence about arbitration generally would not be enforceable. So anyway, hopefully that was helpful. If you have any questions, you can always contact my law firm at the phone number listed below in the description, or you can always reach us through our website, chellelaw.com, CHELLE law.com. All right, appreciate you watching the video. Thanks.